Okay, good morning. Welcome to Jotkulture Cultural Cues. Today we have a really distinguished panel with us today, and I'm excited to introduce three amazing, very experienced professors, negotiators to you. And I'll start with Professor N.S.G, who is an honorary professor at Inter-University Center for Intellectual Property Rights Studies at the Cochin University of Science and Technology in India. He's a founder and director of IPRS, and he negotiated on behalf of the government of India for traditional knowledge some years ago. And I also have Dr. Naren with me. He's an assistant professor at Rajiv Gandhi School of Intellectual Property Law, and he has extensive experience in intellectual property and biodiversity governance. And last but not least, I have Professor Sri Ragavan from Texas A&M University. She also has extensive experience in intellectual property and traditional knowledge, and she is the director of the international programs at Texas A&M. So welcome to all of you this morning. I'm so excited to have you here. If there's anything you'd like to add to the profile or anything that you'd like to add to your experience before we jump in, please feel free. Okay, so Prof. N.S.G. Shri, let's just start with a brief introduction of traditional knowledge before we get into the details of the negotiations and your expertise in this area. So what are we talking about when we talk about traditional knowledge? Prof. N.S.G., would you like to start us off?
Well, when we talk about traditional knowledge, we are really talking about, in one sense, the culture of a large set of people who survived in different parts of the world from long period of time, largely located in Asia, African region, Latin America, and even in the new world of America or even in Europe. So this is their tradition. That tradition has a lot of knowledge which they have been using from generation to generation. And that set of knowledge spread into almost every activity of that set of people. Over a period of time, because of development, we see large number of people who become, in quote, developed, and there is large set of other set of people who are still following this set of tradition and surviving based upon this tradition. And this tradition is a reflection of, in olden days, we call it folklore, which is a combination of dance, music, their medical practices, agricultural practices, etc. It is also linked to their cultural heritage to some extent. So it's a body of knowledge, sum and substance of set of people who were nurturing and nourishing it from generation to generation and closely linked to the community who is holding it, their culture, tradition, and background, to put it simple.
Great, thank you. So I heard culture, tradition, and background, and you use words like nurturing. So people are nurturing these traditions from generation to generation, right? And you talked about songs and dances. And it could be medicinal knowledge as well, right? So, and this is what we're talking about when we talk about traditional knowledge. And there have been negotiations related to traditional knowledge, and if you could start just kick us off, Prof. N.S.G, because I don't think most people understand or are aware that traditional knowledge is something that is real, that there have been negotiations happening at the international level, and that this is something that matters and that governments are paying attention to. So could you just tell us a little bit about the negotiations on traditional knowledge?
Yeah, I think basically, though I was assisting Government of India from 2000 onwards, I got into real negotiation somewhere in 2009. And this period, I will call 2009 to 2015, somewhere around, or even 18, is a second stage of the negotiation to get the background. The first stage was a preparatory stage where a lot of studies that went into including the fact-finding mission that went around throughout the world by the WIPO to understand what the people want, what are their problems, etc. Now, uh, in this stage, actually, what I joined as an expert, because this was a period where experts from almost all the part of the world was invited to look into the existing documents and then bring out a legal text which can be used as a foundation for future negotiations. Now, if you ask what exactly was the role which India was doing at that period of time, before I get a little more detail. Now, this was a period where there was a considerable amount of confusion with reference to understanding traditional knowledge. What are its basic elements? How is it connected to community? Is there a connection between the community? Where is it actually located now? And so the role India played, being the custodian of a large tradition, is to first to facilitate countries, particularly countries who are not familiar with this concept, the challenges of protecting TK, the need for protecting TK, the custodians who are surviving based upon this TK, the tradition that is disappearing, quite a lot of value that has been added to by them during the period of time. And second, to bring clarity to the basic issues of protecting TK and the need for protecting TK, so that there is clear platform on which we move forward with clarity. And of course, we also had the mandate or a role to play to have a clear text, because the text that was available on the table was so clumsy. There was no clarity on it. The issues were so scattered. So our role was also to make sure that there is a legal text accommodating multiple views, because when you move on, you realize that there are multiple views that exist within the countries and outside the countries, etc. And we are also trying to coordinate with like-minded countries, because different region has different set of problems. The problems of traditional knowledge and traditional holders in India is different from that of the traditional knowledge and traditional knowledge holders in Africa. Same is the case with the rest of the Asian countries. So we were also trying to bring together like-minded countries and then trying to sit together and try to understand the specific, what you call the domestic problems TK holding countries were having, and also try to understand what are the challenge, what are the problems the people who are looking for access to TK. Now, now what we really faced during the period of time is one, there are three set of stakeholders when you look at TK. The most important is the community. People were not in a position to understand that TK is a dynamic set of knowledge. It was growing from day one, and it continues to grow even today, because people add value to it when it is being passed on from generation to generation. So they become the most important central stakeholders there. Then the second set of problem or stakeholders are the researchers, because as you know, TK is now subject to modern research, particularly biotechnology, the most important. The people could do research over the knowledge system. They can collect the information from the community. They can study the characteristics of it using modern, isolate the genetic materials involved in it, and then move on with producing new products and then marketing it on. So there is a large number of people throughout the world into research in traditional knowledge-based materials, particularly genetic materials. And third, you have industries. This was the major challenge, because you have two sets of industries. One is the industries who are using TK as it is, the traditional knowledge as it is. For example, in the Indian context, we have a big Ayurvedic industry. So the Ayurvedic industry is producing the traditional knowledge that was existing and the products coming out of it. And then you have modern industries, that is biotech industries, particularly pharma industries. So, the very important thing is to understand the different interests these people have. The TK holders are interested to make sure that their culture and identity is kept intact. One, they are willing to share the information, but they must be protected. There should not be any misappropriation. Say they should be taken into board, consulted, given permission to move on. Uh, and the scientists are looking for access because they need access. So there is a lot of bioprospecting that takes place. They go around and then collect information from the community. The communities, as you know, in some parts of the world, they are very innocent, very honest people. They don't understand what is going on. They are very curious and keen and share their information. They come back to the laboratory, produces things, and then you know that it goes into the patent office in many occasions.
Yes.
So the new products gets patented. Sometimes traditional knowledge per se gets patented. Sometimes value-added products gets patented. And then it moves on to industry and we slowly start getting products into the market. Now, the tragic part is there is no benefit flowing back to the community. It is their knowledge which acts as a base and which has been, of course, there is value addition from the modern scientist and modern industry. But then once they make a huge profit, normally the IP system envisages that there is a flow back by money to the creator. So if the communities were responsible for creating it, there is absolutely no flowing back. So that was the biggest problem that community needs to understand, the scientist needs to understand, the industry needs to understand and find out a mechanism how, with their permission, if it moves on and reaches the market, there must be a mutual benefit flowing on. That's probably something which is to be flagged when we move on.
The benefit sharing.
Benefit sharing.
No, that's really helpful. Thank you for. Sorry to interrupt you. This is really helpful to have the overall explanation of TK, and there are a couple of points that you made that I'd love to pick up on and maybe bring Prof. Naren into the conversation and Prof. Sri as well, because you talked a bit about researchers and scientists in industry and biotechnology. So there are companies that are using this TK and getting benefits from the TK, but there's not the benefit flowing back to the community. And Prof, Naren, I believe you were the head of the legal division of the IPR section of the National Biodiversity Authority in India. Can you talk a little bit about the connection between TK and biotechnology and just pick up from where Prof. N.S.G. left off?
Yes. So thank you, Jan. India already have a legislation. It is the Biological Diversity Act. So the Act has two subject matters. One is the genetic resource, another one is traditional knowledge. So both are actually regulated. We have a national law in India. We already have a national law. So the Biological Diversity Authority is the CNA, the competent national authority under the Nagoya Protocol and the CBD. So NBA's role, NBA means the National Biodiversity Authority's role is to regulate access to both the biological resource and traditional knowledge. So that means...
Can I just interrupt you for a moment to tell us what is the Nagoya Protocol? I know it, but for those that are watching, and the biodiversity, just to give a little bit of background so people can understand. Thank you.
Okay. So the international framework for regulation of activities related to biological resource, that is genetic resource and traditional knowledge, is the Convention on Biological Diversity from 1992 onwards, and then subsequently a protocol called Nagoya Protocol, which came into force in 2010. So this constitutes the international framework for regulation of genetic resources. So the convention recognizes the sovereign rights of countries on genetic resource. So that means if the genetic resource belongs to a country like India, then the activities related to the use of genetic resource should be in accordance with the Indian law. So this means the countries can have their national legislation to regulate the activities related to genetic resource and traditional knowledge. So India already had a national legislation from 2002 onwards. So now almost 2 decades is over. So under the national law, The competent national authority is the National Biodiversity Authority. So NBA is the authority to regulate these activities. So I was heading the IPR division in National Biodiversity Authority. So where if any person wants to take intellectual property rights on any invention which is based on genetic resource or traditional knowledge, then they needs to secure the approval from the National Biodiversity Authority.
And could you just give us an example of a genetic resource that somebody would take and then secure IPR? Because there's a lot of Indian traditional knowledge, I think, that's being used throughout the world. So maybe you can just give us a concrete example of something that
Yes.
would be a genetic resource in that way.
Yes, India is a major exporter of all types of biological resource because we are a mega biodiverse country. So that means a lot of biological resource from India is being used in different parts of the world. So there are actually more than 3,000 cases where Indian genetic resources has been legally accessed and then intellectual property rights has been secured. So there are examples like curcuma longa, which is commonly known as turmeric, which also has an associated traditional knowledge in India with regard to its cosmetic or therapeutic effect. And then there are other biological resources like Pterocarpus santalinus, which is red santus. So this is a very precious wood and which is also being used in different parts of the world. So this is endemic resource in India. So that means it will not normally or grow in other parts of the world. So if you want to access the wood, then the access also always has to be from India. So all these biological resources, there are several intellectual property rights being filed.
But I believe, thank you. I believe that with turmeric, for example, if I'm not mistaken, Tree, there was a patent filed in the United States, obtained, and then the Indian government worked to have that invalidated. I mean, turmeric, people know as a spice and it has medicinal properties, but how would you get IPR over something like turmeric, or should there be no patent right involved?
Absolutely. So much of the issue of IPR comes in when traditional knowledge or traditional resources are taken, and then there is more. I want to say human intervention to develop it and to add some technological or some additional research into it, and then it becomes, and make it a little more distinctive. Data is collected, and then patent applications are filed. So, given this question, I want to circle back to the definition of traditional knowledge to just add to what Professor N.S.G said. The issue comes, the issue of protecting traditional knowledge comes. Because much of the base material is derived from traditional knowledge. So, this is the difference between trying to figure out, say, what causes cancer versus, and then trying to then figure out how do we cure it, versus, I know if I eat this berry, it can cure this form of cancer. So you already are a couple of steps ahead, right? So the value of traditional knowledge is the economic value is really the value of those two steps, which pharma, the pharmaceutical association, right, usually insists is that particular, it is that step that requires a lot of research and investment. So use of such base material, right, saves time. It makes it time efficient, cost efficient, and then people know what they are going towards. You're not just running a race, you're now running a clear race where you know if I go through this path, I'm going to end up with a patent and with a pot of gold at the end of the patent, as opposed to I'm running, maybe I'll get a pot of gold at the end of the run, right? So, and that clarity minimizes the associated risk. And risk is the most important thing corporates are trying to, minimize and capitalize on, right? So that is the value of traditional knowledge, and that's the value that has to be captured, right? What typically happens, and I, thank both Professor Narayan as well as Professor N.S.G for setting the table, is much of these, when patents are filed, becomes, privileged property, like pharmaceuticals, like, things like, or cosmetics, and, and they're all sold at a high value, which, there are two ways to look at it. One is Look, they need a portion of the profits. But the sad part is a lot of times the traditional community don't even have access to it. Like, I mean, can you imagine a situation where the community says very X cures, I don't know, acne, and then it's developed, and then acne medication is produced, and then they themselves are unable to afford that medication. I think that's a bit of a travesty that has to be addressed, right? So when we talk about recognition of traditional knowledge, it is to appreciate the value in it. It is to accept the ideological divide we have with IP, right? We realize there are ideological divides with IP, but there is no need to construe IP as the only ideology that one needs to, to focus on, right? So it's very important to appreciate the ideological divide and then find the middle ground. So parties that actually minimize the risk. I mean, in a corporate setting, a graduate, I don't know, lawyer or a management trainee who reduces corporate risk would be richly rewarded. So I don't see a reason why somebody from the traditional community who can minimize corporate risk in developing R&D cannot be, cannot be in line for similar rewards. That's the vantage from which this discussion takes off.
Okay, thank you for that, Shri. And let me just circle back to something that Prof. N.S.G said, because you're talking about corporate risk and developing products, but Prof. N.S.G said in his introductory part that traditional knowledge has a way in which it is innovative, in the sense that he said that the knowledge is not static, right, Prof. N.S.G, that people are continuing to evolve it and to develop this knowledge over time, even though it's passed down through generation to generation. So can we talk a little bit about what is that gap between traditional knowledge, if it is innovative, and the patent and IP system, which rewards innovation? So whether Prof. N.S.G or open that to any of you who'd like to tackle that.
Yeah, I think that's the crux of the issue. Now, when you talk about patent, we talk about new knowledge, not the existing knowledge. So technically, we say novelty, inventive step, and industrial application. But simply put it, we want some what you call substantial value addition to the existing knowledge for the purpose of getting patent. And this value addition, again, technically speaking, is the first value is fixed. I mean, it is written down. People can understand what is the value. It is detailed. And then again, you write it down by demonstrating that this is the value addition made, and there is substantial value addition added, which is good enough or qualify for me to get a patent. When we move on to traditional knowledge is existing knowledge in many ways, because the foundations remain as it is. The foundation won't change immediately. It is that foundation where slow value addition takes place based upon the experience of people which has been working on it. So the conceptual difference is, one is an existing knowledge, the other one is a new value added knowledge on that. So when you speak about protecting traditional knowledge, we are really speaking about protecting some values, some knowledge system which has already been created, maybe sometimes a couple of generations back. Or even we may not be even in a position to specifically identify the period or the date on which it has been developed. Second, we may also not be in a position to identify the particular person who has developed it or added value it, which is possible with reference to patent is concerned. We have the inventor, we know who is the scientist, how long he worked, etc. So there is a typical problem of identifying that person, but it was nurtured and nourished by a group of people. That's a community, unlike the patent, right, where you see an individual holding it and a company manufacturing it, and another person who is adding value to it, who can again be identified. In case of traditional knowledge, this value addition takes place in a cultural community setting, whether collectively people join together to add value to it and innovate it and take it forward from generation to generation. So this is the conceptual difference you see when you evaluate it from the IP perspective. A conflict between, or a tussle between, an existing knowledge which is evolving through a community process and a new knowledge which evolves in an individualistic perspective. So it's one is individual centric, the other is what you call collective human beings value additions centric, to put it briefly.
Okay.
I will come back if you have an additional question to add.
So what would you say then, Prof. N.S.G, is the key distinction? I know Prof. Shri was talking about ideologies, and so you're talking about one that's community based and has a particular kind of innovation, and one that's more individualistic, that's adding substantive new knowledge, right? Or do you think that's a fair description of the differences? One is community based, one is individualistic, or how would you describe the core difference? Because people think pe- people think when we're talking about patents, right, the justification is reward it because you're bringing something new and you're contributing to innovation overall. And with traditional knowledge, it's not just about the community versus the individual, perhaps, but the sense that this knowledge is existing, right? You said one is existing, one is new, but really, is that just the fair core distinction? Because it's easy to say, in that case, traditional knowledge is already there, maybe it shouldn't be protected, right? We reward the inventor for 20 years because they've brought something substantive and made a significant contribution. How do you respond to that? Like, how do we respond to that critique that TK is existing and it shouldn't be protected? Because you use words like innovation and the community nurturing it. But how would you respond to somebody saying, well, that doesn't matter. It's not the same as a substantive new knowledge that's being brought through a patent.
So I believe this is the area where TK has to be reconciled with IP. It's a different level of, it's a different level of contribution and a different type of contribution. I remember a scholar here in the US once asked me, well, then if you want to protect traditional knowledge, then you would protect electricity too, because electricity is, or the internet, and, how is it different, right?
Right.
So electricity and the internet is used for every innovation, right? Those are base operational materials, but this is base knowledge that minimizes the risk. And it's very important to segregate what we are protecting and how much value it adds, right? So there are two ways to look at this as well. One is, I mean, obviously we want IP to embrace it. And so we have basically looked at it from the intellectual property lens, which forces us to look at how is TK different from, let's say, Western
IP.
intellectual property
Yeah.
rights, right? Why not
Mm-hmm.
flip it and then say, look, if it comes from this community and we have borrowed your knowledge, let's downgrade the level of IP we apply to this particular substance. Somehow flipping it never applies, because that's one way to reconcile IP too. We downgrade it either by price, we can downgrade either by the level of protection, we can downgrade it by the type of patents we award. We have design patents, we have utility patents. Why not have a separate type of patents that embody traditional knowledge? Or why not call it something else, right? Doesn't have to be called patents. So, it's time to acknowledge that difference and then reconcile them in a way that we don't leave people behind. And if I can take, I do a lot of work in access to medication, right? So I want to take a leaf from the COVID example. And the trade was very different pre-COVID and post-COVID, right? So pre-COVID, trade was the most important thing. And so those who were knowledge bearers considered themselves as to be the important, global contributors or whatever. COVID was a leveler. It doesn't matter where you live. diseases travel, things travel. We live in a world where things that happen in one part of the world affects another part of the world, right? So it's very important to reconcile and treat the world. You can't leave behind one set of people, one part of the world, and then say, look, all these laws apply for the greatest happiness of of mankind, and the greatest happiness somehow is only a portion of the world that we identify as requiring that greatest, the benefits of the greatest innovation, right? So I think that should be the objective of this whole exercise, to reframe the debate to be more sort of inclusive, right? and
That
and
yeah,
uh, and take it from that vantage.
yeah, it's interesting that you say that. About not leaving anybody behind because we're all affected, and I think that's really coming out a lot in the discussion around the environment because even with the smoke that we're sitting in the US or smoke that's coming from Canada is blowing all over the place. And so I think people are thinking, oh, right, we're all dealing with the climate change together, right? Um, Prof. Narendran, I want to bring you into this conversation a little bit to talk a bit more about your work and your role. I see that India was the first country to issue an internationally recognized certificate of compliance under Nagoya Protocol for accessing ethnomedicinal traditional knowledge of a tribal community. Can you talk to us a little bit about that?
So this IRCC is actually internationally recognized certificate of compliance. So this is issued under the Nagoya Protocol. So once a legal access to traditional knowledge happens, so legal access means that the access is in accordance with the law of the provider country. So if the traditional knowledge is from India, then the Indian law has to be followed, and then the government authorities in India has to issue an IRCC. So this IRCC evidences that the prior informed consent, so that is another main issue, that prior informed consent of the traditional community has to be obtained. And then the second part is the material, the mutually agreed terms. So the benefit sharing terms has to be discussed between the community and the potential user of the traditional knowledge. And once this is agreed to, the mutually agreed terms, it's in the form of an agreement. So the agreement will be finalized. And once these two, the prior informed consent and mutually agreed terms has been finalized, then the IRCC will be issued by the government authorities. So the IRCC evidences that the traditional knowledge has been legally accessed. So India was the first country to issue an IRCC. So that was for accessing traditional knowledge from a community called Siddhi community. So, but the interesting aspect is that even now, one of the major issues with regard to traditional knowledge is that sometimes it can also have transboundary nature. So this traditional knowledge also has that issue because the Siddhi community originated from the Africa. So they traveled to different parts of South Asia, and some communities have settled in India as well. So then the issue comes because the traditional knowledge also has undergone some improvisation, because the improvisation has happened recently, but maybe 200 or 300 years back. So because when they travel across the continents, then the type of biological resource that they use, the type of species that they use also changes. So the ethnomedicinal knowledge also has undergone some change. So these are some interesting aspects. But India was the first country to
Are you
issue
able to tell
IRCC.
us a little bit more about that? Is it something that's confidential? Can you share what, for example, was the knowledge and just tell us a little bit more about it? Or are you not able to do that?
The exact information regarding the species and the type of knowledge is confidential. So that is the issue. But generally, it is about the ethnomedicinal knowledge regarding some of the species that they use. So they say that it is having some medicinal effect, the use of the species, and the way in which the material is used, the procedure also has some significance. So these
So
are the
this is an
interesting.
issue with TK as well, right? Because sometimes the medicinal knowledge is closely held and is held in secret. So how does that square with having this traditional knowledge digital library and trying to categorize the traditional knowledge when there is this element of secrecy? How have you dealt with that? How has that been managed?
So the documentation of traditional knowledge is another issue because the proposed text under negotiation in the international level also speaks about documentation of traditional knowledge. But documentation of traditional knowledge is a big challenge, And completely documenting all the traditional knowledge in India is actually impossible. It will never happen. But some efforts has already happened in the form of traditional knowledge digital library, which is a government initiative. And there, with the traditional knowledge, which is in already documented form, was translated into different languages. But this was only for providing a defensive protection against misappropriation. But now there is also another exercise happening at the national level in the form of People's Biodiversity Register. So this is a it's a community involved initiative to document traditional knowledge at community level. But this also is never going to be completed because it's a big task. It will never, we can say that the complete documentation of TK will never happen because most of the traditional knowledge will be in oral form. But up to some level, the documentation will give some form of protection.
So, if the traditional knowledge cannot be necessarily documented and it's secret, how do you monitor misappropriation of genetic resources? How do you manage the traditional knowledge so that it's protected from outsiders coming and taking those genetic materials that are associated with the TK and using it based on whatever conversations they may have with people who don't realize what's going on?
So the documentation could make two positive impacts. So one is that it can prevent against misappropriation through patenting, because once this is documented, because some countries IP laws also require that if it is a prior act, it has to be in some documented form. And second is that it will give for protection because many times what happens is the traditional communities also have undergone change, and they also stops using this traditional knowledge. So it also gives a long-term protection. But then another issue is that this also requires strong legal framework at the international level, because misappropriation is a global issue. It is not just national issue. So that means the Nagoya Protocol already speaks of checkpoints. So checkpoints in the form of patent offices. So when an IP application comes, the patent office also sees whether there is a traditional knowledge involved. And if there is a traditional knowledge, it has to be in compliance with the access and benefit sharing regulations. So we are expecting that once this the international agreement is finalized, and then it will give some form of protection to the traditional knowledge against the misappropriation.
So this is traditional knowledge that's associated with genetic materials, which I know there's some work happening at WIPO, the World Intellectual Property Organization, right now. But I just wanted to take a step back for a moment and talk about traditional knowledge. What are your thoughts on traditional knowledge, Indian traditional knowledge more broadly? And maybe Prof. N.S.G. or Shri, either one of you might have some thoughts on this as well. That's not TK that is associated with genetic materials. So what are the other kinds of traditional knowledge and other activities in terms of protecting traditional knowledge in India that's not genetic material focused?
Folklore, for instance, is a great example, I think. It doesn't involve genetic material, but it still involves a lot of intellectual property rights. Of late, we are also seeing litigation on trademarks. People appropriate logos and symbols, right, from traditional cultural practices, names, Sanskritam names that are taken and then misappropriated. We see that as well. And then in the GI field, slowly we are seeing a lot of misappropriation. The other day I was walking, I think this was, I was going to a store and I saw a shampoo with the name Shikai, right? And Shikai is actually the name of a product, is a naturally occurring, it's a vegetation in India used for hair care, right? And I was like, wow, they use that name, right? It's going to become like yoga in a period of 50 years, right? And people are going to associate it with a brand now, right? So, you know, so that's part of the problem, right? And I can say in the past 20 years, that I've been in legal academia, I have seen that countries have reluctantly but slowly have started introducing legislation that pretty much says, look, if you're using traditional knowledge, you should disclose. But it's all done as part of patent disclosure. right? And some of it is done to please, oh, let's please India because we need that market. Let's please Brazil because it's a big market, or China, something like that, right? So it's not really out of a concern that, look, we are cheating them, or it doesn't come from any sort of realization like that, right? Whereas you see in the drug arena, even today, generic drugs are still referred to as copycats. They're not copycats, they are off patent drugs. We still call them copycats. Whereas we have no moral issues when we take from a traditional tribe and then get a patent and refuse to give them the medication for which they produce the knowledge source, right? So that some
Is
of it goes
TK
back
only
to
a moral
education.
issue? Is TK
It's
only a
not
moral
just,
issue?
that's a great question. It's not just a moral issue. So that education of how that leads to legal rights should actually happen at a much higher level, right? In some ways, the TRIPS agreement, I think, has been a success in educating people on IP rights. But
That's the World Trade
CBD on the
Organization agreement.
yeah, yes, of course, of the World Trade Organization. We need the CBD, the Convention on Biological Diversity, which does the work for traditional knowledge, and then the World Intellectual Property Rights to do that job of educating people of the importance of rights and or obligations that are involved in the realm of traditional knowledge.
Okay, so let's talk a little bit about what's happening right now. So I know there are negotiations happening. There's a diplomatic conference. There's some work happening at the World Intellectual Property Organization on the traditional knowledge associated with genetic resources, and that they're supposed to have conclude a legal instrument relating to that. So, Prof. N.S.G, can you tell us a little bit about that?
Initially, there were three sets of, it was one issue of folklore and genetic resources. Then it split into three issues. One is protecting traditional knowledge. Second is protecting traditional cultural expressions. And third is the issue relating to genetic resources, traditional knowledge associated with genetic resources. Now, Narendran was telling about CBD, which laid the foundation for linking genetic resources with traditional knowledge. But it left quite a lot of things unexplained and unattended. Over a period of time, when people started implementing it, they realized quite a lot of gap. One of the important gaps, which again Narendran was mentioning, is there is a checkpoint. Who is the best person to identify and then bring out, and what are the obligations from different set of people, the stakeholders involved? Now, as we know, the traditional community has a lot of disadvantages in tracking how their knowledge is being taken out, particularly when their knowledge is not at all secret. Once it is secret, probably they know who came and who discussed with them. But traditional knowledge, entire set of traditional knowledge is not secret. Now, it's only one set of traditional knowledge which is secret, but large number of valuable traditional knowledge is either spread or widely spread. Let me use that terminology to understand the magnitude of the problem. So it becomes extremely difficult for the community to track and find out where it is using, who is using, where he is going, etc. So one of the problem which has been identified as one of the major problem is the patenting issue. Though there is misappropriation, traditional knowledge per se, let me say, without any value addition. So the value addition is the one that become very serious, because that was the one which brought up the whole issue into the table from a trade perspective. Because industry spend quite a lot of money, they want to market and get the money back. So once you go to the patent office, you have two sets of problem. One set of problem is to find out whether traditional knowledge is used. That is one. Second set of problem is whether there is actual value addition from the traditional knowledge. So there was a lot of arguments by saying that The guys who are not doing any value addition, they simply identify the essential characteristics and then patent it without taking any permission or any value addition. Turmeric case in US was an example of that. There is no value addition that took place. The second is, now, of course, in case of turmeric, we know from where it is coming from, so it becomes much easier for it. But if it is a knowledge which is more community specific, and particularly if it is not documented, then you have a typical problem of both identifying from where it is coming from, the source of the knowledge, and also the knowledge itself. What set of knowledge has been used by these guys? So that is where the entire issue of disclosure of the information along with the patent document came in, surfaced actually as a way of looking at it. So once you file a patent application, you know as a scientist from where the knowledge has come from.
Right.
Whether it is from a published document or from an unpublished document, you can't say that I don't know from where I got this material. And I don't know which material. You are not talking about something which you don't know. You are not traveling into a forest and picking something and start doing research. It's very unacceptable. 99%, I may say 99.9% of the research is based upon information, either document or undocumented. If it is documented, you know from which document, what is a species or what is a material. If it is undocumented, you know from where you collected it. So tell us honestly from where you have collected it, from whom you have collected it, what information you have collected it, describe it. So it will do two purposes. One purpose is you know from where it is coming from, so you can locate the country from where you took the material and the person from whom the material is taken. If it is not person specific, at least you can track it and find it out from where it is coming from. One. Second, you also know the knowledge which you have used as a base knowledge. So it discloses the knowledge you have taken. It discloses the person who have taken it on that. So disclosure become the most contentious issue from day one when we talked about GR and TK. Because in GR, people are willing to give consent. People are willing to give it. But then consent taking, etc., is not part of the negotiation in WIPO. That has already been taken care of by the CBD and Nagoya. But in WIPO, it's an intellectual property. So it's a patent document that is before you, or any other IP document which is in before you. And the patent office or any IP office is the office which is capable of doing it. So please disclose it. And in the disclosure, you also disclose whether you have taken prior permission from the community, because then you comply with it. So it's a tracking mechanism of where the GR is going on the one side, and also a compliance with equity principle, the justice principle on which you are operating on that. You disclose in your patent application the previous patents already existing. You cannot operate a patent which is an existing patent without a consent. So there is a real logic behind it, because you respect the existing patents. So why can't you accept it? So that's an interesting debate that has been tabled on. And that is precisely the one which is moving on, in addition to the preparation of databases and things like that. So let me put it here and then allow the others to chip it in.
Okay, so thank you so much for that. Let me just ask one follow-up question for all of you, and for you, starting with you, Prof. N.S.G. What are you expecting then in terms of the diplomatic conference? Because you've told us a bit about what has already been covered by Nagoya and sort of the IP problem. Do you have expectations for this negotiation? Do you have a sense of where things should probably go? And I ask you that, as an expert in IP and somebody who's negotiated in the past, recognizing that India has been a leader on issues of traditional knowledge in the international space.
Now, this is going to be the greatest challenge any negotiator from India is going to face. Luckily, I'm not. The reason being, now, even though you are negotiating disclosure requirement, indirectly you are negotiating the subject matter of traditional knowledge. You need to find out a definition for traditional knowledge, because that is central. And that is one major issue that has been always been worrying the entire negotiating people. How will you define what characteristics you will add, what eligibility conditions you will add for the purpose of doing it? Whether you want a broad definition or a narrow definition, how will you accommodate it? Particularly given the nature of the traditional knowledge, which is very close, secret, sacred, and then spread little bit because couple of communities know it, and then you have something which is widely spread. So how will you accommodate all these things into your definition? Because disclosure is not confined to only secret knowledge. So you need to accommodate. And look at CBD. CBD is not talking about secret knowledge. CBD is talking about any information on any genetic material which you are taking out. So, for example, we are talking about turmeric.
Yes.
So that means it's a very disclosed information you are talking about. So you need to address that issue centrally before it. So any negotiating outcome of this treaty is going to have a impact on the pending negotiation on the rest of the traditional knowledge which is been pending on that. That's one. Second is, how will you address the issue of mandatory disclosure requirement? Should it be mandatory or should it be optional? If it is not mandatory, it makes no sense. Then there are a couple of issues with reference to non-identifying it, which I will always say is a minor set of issues, because there are options available on the table which can fit in by saying that if you don't know, you declare it and you come back and then say. So there are multiple options on the table. But is there going to be a willingness from the part of the two sets of negotiators? I mean, people who are demanding for a protection, people who are looking for a solution to make trade more easy and less cumbersome, to draw a line between them and then move forward. I could see a couple of options available on the document, which can be moved forward to reach a conclusion in many ways, leaving many things open for the next round of negotiation to go. So I am very optimistic by saying that yes, people may reach a conclusion provided they are willing to move forward. The trade group wanting to have a solution because they want to have a smooth trade on this, because TK has become a global issue now. The traders are too much worried. Many countries have already laws for access and benefit sharing, so they need to have an international framework for that. So I'm little optimistic by saying that there will be a middle path and they may end a conclusion. But it can also break if the two sides are going to be too tough on negotiating, particularly if they go for a definition of TK. That's how I see it.
And you got to have a definition, right? It's going to be challenging without one, I think. What about you, Prof. Shreen, Prof. Narendran? What are your thoughts? Do you have any expectations for the negotiations that are ongoing?
Was that to me or Naren?
I've asked both. I said both of you, Prof. Shree, Prof. Narendran. I don't know whichever one of you wants to go first.
Sure. I'll go first. It's okay. So my thought is, this is one area where the trilateral cooperation has to work together, right? We see in some ways that some of the issues relate to trade, intellectual property, has direct bearing to health, direct bearing to the digital access and digital divide questions. So, considering all of this, I feel this is one area where WIPO can use its role as one of the important members of the 3-member panel of the trilateral cooperation, and then try to bring consensus in a way that issues relating to defining it, identifying the limitations and so on and so forth are discussed well, and each organization agrees, like the WHO, where TK is used to create health products, and the WTO, where TK is used to create IP, can all work together to probably bring in a better angle to this. Do I have an expectation? I don't know. I mean, that's a different question. One is ideological, the other is, of course, what is the expectation? The idea is we will move one step forward, not much more. And the one step forward will be to define, to actually pass its TK as knowledge uh, and something that has value. And over a period of time, I suppose it will, the definitions will get refined, and it will contribute to more sort of education about this, and kickstart a process that'll get refined over a period of time.
And Sri, you talked about trilateral cooperation. You're talking about the World Health Organization, the World Trade Organization, and the World Intellectual Property Organization as the three organizations that are cooperating. Okay, thank you. Prof. Narendran, do you have any expectations for the negotiations?
Yes, I feel that it is going to be a big challenge in arriving at a consensus, because different parties have different interests, and these are all conflicting. So it's going to be a big challenge. And then, just like N.S.G said, then arriving at a proper definition from traditional knowledge, because in other IPs, with regard to other IPs, we have a clear subject matter identification. But having that clear subject matter identification is also going to be a serious challenge. And even with regard to the use of different terminologies like misuse, misappropriation, arriving at a consensus is going to be a challenge. But I feel that there is going to be some significant advancement. And of course, we are expecting that there will be some form of legal framework to prevent the misappropriation of traditional knowledge and give some form of protection.
Okay, great. And you just talked about the misappropriation of traditional knowledge. Can you talk a little bit about what cultural appropriation has to do with traditional knowledge? Is misappropriation the same thing as cultural appropriation, given that we've talked about traditional knowledge as being part of cultural heritage? Is it a confused conversation, right? Because people talk about yoga and whether that's cultural appropriation. What are your thoughts on the connection between traditional knowledge and the conversations about cultural appropriation? I open that up to all of you, whoever would like to jump in first.
Well, let me take the challenge. Those who understand traditional knowledge will understand there is a core element in traditional knowledge, which is the value system of the community, which is the culture. And then the specific elements that is associated with that is the different type of activities or products that evolve out of that. So, it may not be a right comparison. The ideas we talk and the expressions we talk on the one side. So the culture is a very broad concept which captures within it the way of life in many ways. So the knowledge system evolved out of that culture. So when they take this core element from them, they believe that there is a cultural misappropriation, because the core element has been taken out, rather than some specific stuff that moves out, which may not be very serious as far as comes. In many of these things, particularly some of you mentioned about yoga, for example.
Yes.
Those in India will understand what is happening in US is not yoga in many ways. So,
okay.
Yeah, because yoga in its unique sense means your body and mind blend together, and you evolve as a different set of human being, if I use the word human being, on a particular state of mind. And that you achieve by movement of your different parts of the body, and then focus it on to your mind and beyond, if you look at it. And that's the core. So when you do the exercise and say, I am doing yoga, you are culturally misappropriating it, because you are not doing
it's not yoga anymore. Okay.
Absolutely. It is exercise in many sense. I came across that you will achieve Kundalini within 1 week. Kundalini is something, if you read yoga posture, is something of your energy that lives at the bottom of your spine, which slowly moves upward and reaches to your brain, where you reach a total different stage of mind, which requires a constant long-term exercise and focus. So the culture of Kundalini is being siphoned out by way of exercise. So this is cultural misappropriation.
Because
When
people come to
compared to your
misunderstand it then. People misunderstand it, right? They go, I went to exercise, I'm doing yoga,
Exactly.
right? And they're
Yeah.
not really doing yoga,
Exactly.
like proper.
Exactly. And that happens
So,
even in
but what's the
India.
harm?
Yeah.
Even in India. What's the harm? Can you talk about the harm that comes from that?
No, I'm
Can I
not
just
talking
jump
about
in
yoga
here?
as a harm, because my Prime Minister has said, Vasudeva Kudumbakam, yoga for Vasudeva Kudumbakam. Vasudeva Kudumbakam means the global house. So for us, we are willing to part with that, but that need not be true with
Okay.
a community who is too much bind by that. Over a period of time, you get adjusted to your culture being taken out. You accommodate it. That happens in everywhere. When we move from, as a human being, when we move from a child to when you reach, grow and grow, and you can ask, she was born in Chennai, in Tamil Nadu, a cultural settings, and then studied in National School, Bangalore, a different cultural settings, and then moved on to US and then living there for the last 20 years. So we do accommodate certain cultural transformation and
We do.
changes and appropriations. But
We
something
do.
which is very central to you, you may find it very, very upset. And that is happening with the
Yes.
communities who are even now residing with that cultural ideology and cultural setting. That's where the cultural misappropriation become very central. I think I am understand that the Africans, and there are groups in Africa who are much worried about it when compared to groups in India, because we are to large extent the substantial people are integrated into the main body of the Indian life. So when compared to set of people, we do have people who are still isolated, still in pockets where their traditional culture and value system become very important. But over a period of after independence and the approach we taken towards bringing people to the mainstream, if I use the word, though it is not a right word to use it, had lot of integration that took place. So some communities may feel it, some communities may not feel it on that sense. We ourselves move to other countries to transmit our tradition and culture. So if you ask who propagated yoga in United States, there are a lot of yogis that went into United States and set up ashrams
Yeah.
for the purpose of promoting it in many ways. So we do promote culture. So you don't feel that there is a cultural shock on it. But that need not be true with the communities. So that's whether I see the difference between culture and hope I made my point clear.
Yes.
Can
Thank you.
I jump in to say something here? And I want to compliment what Professor N.S.G said. See, there is something called cultural fusion, and that's welcome, and that's okay,
Yes.
right? We
Absolutely.
want to
Yeah.
learn good practices from other cultures, right? But that's not the original culture, right? Uh, Cultural misappropriation is when we actually do cultural fusion but think that we practice the original culture. So fusion is fine. It's welcome. It's needed, and and that's how we become more inclusive. But the appropriation aspect of it comes when we don't give adequate, what's the right word? When we don't adequately, because I'm a professor and a law professor, the word that I can think of is citation. When we don't acknowledge the origins of that original culture. I mean, we may give a passing reference to yoga came from India, but that's very different from understanding the depth of it and then saying, look, I've developed on this yoga. And I have a very small example. Sometime back in Oklahoma, one of the Zumba teachers said they are now certified in yoga. And then she went on to say, and I'm going to teach this without all that crazy chanting, right? And I literally froze. And I told her, crazy chanting? Have you been to a church? Have you seen choir service? I don't say it's crazy shitty. I mean,
Yeah.
do you realize what you're saying there, right? And I mean, she was so shocked. I don't think she meant to hurt anybody, and she thought she made a good joke, and she was
Mm.
surprised that I was so hurt, right? And she didn't think she just thought, oh, I don't have to apologize because it's her fault that she's not understanding what's happening, right? And then I had to explain the whole thing. So that's where the misappropriation comes, right? I mean, it's a culture that's developed over hundreds of years, and then we give a half an hour certificate, and then suddenly right, I'm trained in this practice, right? So it's
I
the
mean,
appropriation portion of it that's troubling.
I wonder even I think even people's awareness that yoga is an Indian practice is probably relatively recent, because I'm sure a lot of people were doing yoga and they just thought it's just some kind of exercise. They don't make any connection to anything
Right.
cultural necessarily. And your point about fusion is interesting, because as you were speaking, I was thinking about the difference between Mexican food and Tex-Mex. I mean, people know that Tex-Mex is kind of like Mexican
Absolutely.
inspired, but they know it's not Mexican,
Yeah.
right? And,
Right.
and of course with things like yoga, you had also the problem of people trying to copyright poses and claim ownership over the yoga poses as though somehow it was their own creation. So,
Right.
that
I was
raises.
actually, sorry, I was
No,
actually
go ahead.
thinking of Milagutani soup. Milagutani soup is actually Milagutani soup, right, which is very Tamil in its origin, right? But here it's Milagutani soup. And nowadays it's such the development of a beef stock Milagutani soup. I'm like, are you kidding me? I mean, from Tamil Nadu, you're getting beef stock Milagutani soup, right? So again, that's cultural fusion. I'm sure a lot of people like it, but that's not the original Milagutani soup. So, as long as we can acknowledge it, that's fine. But if it's our
Well,
refusal to acknowledge.
acknowledge the original, and that's the whole thing, right? And this is where for me it's interesting with intellectual property conversation, because we say it's about sometimes about authenticity and originality that we're trying to protect with names, right? That your champagne is champagne and it's not something else, right? That the copyrighted work is the original work of this author. And so this is an interesting sort of connection, I think, between the traditional knowledge and the IP space. Now, I'm just going to confess that. So for myself, I actually was chasing down an Ayurvedic medicine practitioner, and the person has gone to India and trained in India. But how authentic is it? Well, I mean, I'm not going to know, right? Because I'm not trained in this, but I want access to that knowledge and access to an alternative to Western medicine. But this is something that it's not part of my cultural heritage, right? And this is part of the sharing, right? People might want to, and it's interesting because we don't necessarily know how much is supposed to be held within a community and how much is meant to be shared. But that becomes a complicated thing as a consumer, right? In terms of dealing with
Absolutely.
traditional knowledge. So,
Absolutely.
let me just ask. I want to talk a little bit about you guys' book before we wrap up, because the three of you are writing a book together, and you're writing a book, I believe, on dealing with traditional knowledge and medicinal issues, right? Can you talk a little bit about that?
So I'll take the lead on that. Part of it is, the book itself is an outcome of a conversation I was having with Professor N.S.G. Right. So last year I had the fortune of having so many conversations with Professor N.S.G. on many, many issues that were very personal as well as professional. But, it also drifted into questions of TK, right? And our work, generally. So at some point I said, we've done so much on this independently. And I have to say at this point, any knowledge that I have on IP, all of the basis of that knowledge, I owe it to Professor N.S.G. He was my teacher at law school, right? So so I owe it all to him, right? So
That's
and
awesome.
we were
Kind
reminiscing
of, very
about
kind of you, very kind of you.
oh no, of course, you know, and so we were reminiscing about our days and my days as a student in National Law School and so on. So I said, look, we've written about this independently. We have to put this together, make it a book, and this is the right time because of the WIPO diplomatic conference as well, right? And then the conversation moved on to creating a nice book and to talk about some of the things where we share a lot of mutual synergies, right? On that particular topic. And then NSG then talked about his other student who was doing very well in India on these issues, and that's how Naren came into the picture. And so we ended up talking with Naren, and Naren had a lot of mutual synergies, and Naren also is Professor N.S.G student, and that's how the book came into being. So there's a backstory to the front story in the book. And so far, we've started writing about three important areas: TK, plant genetic resources, and biodiversity. Basically, just focusing on each of our, focus areas and expertise. And so, we're very happy to be doing this book together. And I feel very, very privileged and honored to be working with Professor N.S.G. and, of course, Professor Naren as well. So
That's awesome.
that's the book.
Well, can you tell us a little bit, about why should the average person care about traditional knowledge or biodiversity? So, how does it connect to anyone's everyday life? Why should anybody be interested and care about this topic? How is it important? Can you just, in a few words, tell us about the importance
I'm
of
going to
it?
take the lead on this as well. Several years back as a young academic, I was doing, I don't know if it's a conference or some sort of a video a podcast type thing, and I was asked this question of why do people have to care for genetic medicines, right? And at that time, I said, this is part of the food chain of medicines, right? Because if you can't always afford the most innovative medicines, even sitting in the United States. And at that time, people laughed, right? It's only been about 15 years, and now most people in the United States consume generic medications, right? So
You said most
same
people in the United
about
States use genetic medications. I didn't hear the last part.
generic, as opposed
Generic
to, yeah,
medications.
branded,
Oh,
yeah,
right, by force,
yeah.
actually, yes.
Yes, by force, because we can't always afford, right? The
Yeah.
same thing is applying to traditional knowledge as well. It's part of our food chain for life. As we become a more globalized, diverse society, I can easily see someone in the United States who doesn't know anything about India or Africa or any part of the world other than their little town in the US, right? Getting up, going to a yoga studio, getting a cold, drinking malagatani soup, right? And then you get what I'm saying? Listening to Zumba music, listening to African music, creating fusion music, right? So these are things that are part of our food chain now, right? So it's important to know, right, that as we step into others' boundaries, it's important to be cognizant of it and respect that. Look, I'm stepping onto your boundaries. I'm thankful that I have the opportunity to now take something from your boundary. You get what I'm saying? And that's an important sensitization, just to be a good, just to live your life, to be able to know these are the things I am enjoying, I'm liking. I know so many people who've never been to India using turmeric now, right?
Everybody uses it.
These are,
Yeah.
yes, yeah. You've been to India though, but
I've been to
so many
India,
people,
so I'm allowed to
yeah.
use it.
Right, same with neem, the cream that has neem in it, right? So it's very
Name, yes.
important to appreciate, right, the kind of things that we do and the kind of cultures we integrate into our lives, and that's going to become more and more part of us, I think. And so it's as important to our being as we practice mindful fusion as opposed to thoughtless misappropriation, right? So that's how I.
Mm. Yeah, and
Well,
there's a lot of natural medicine things, like from the turmeric to the shea butter and different things that people are using now. Sorry, Prof. NSG, you were going to say something. Please go ahead.
to add, I think we are also into a stage of transition where we have reached the peak of the modern systems in one
Wow,
way or
that's
other
deep.
way. Uh, I may be little, We feel strong and saying it. And we are now slowly moving back and then asking alternate questions.
Yes.
And
Yes.
then if you look at the country who have reached the peak, let me say United States, where the modern systems, the modern development, the modern medicines or modern food systems, name it, has been the invention of human beings, let me put it. And the marketing of the human beings' invention has to reach the place where we started doubting it, if I use the word, or finding
Yes.
limitations of it, if I put a little more balanced type of a word. We see the limitations on it. And once you see the limitation, you ask, what's the way out? That's one. Second, we also saw the next phase of our innovations based upon biomaterials, the biotechnology and the gene therapy. We talk all sort of things, gene editing, name it, all sort of things. The moment you talk about it, you are also not talking about the modern things you have created. We are also talking about the modern things blended with, if I use the word fusion, with other things. So traditional knowledge suddenly become the central to your living. All
Yes.
from morning, getting up with your first drink to the last drink you take in the night. And the medicines, the exercise, the communication systems, the terminologies, name it. So I say it's a transition of human beings because, it's a cycle if you look at it. And, it's well articulated in the Indian philosophy because the cycle moves on. So you move up and then you reach some deadlocks. Then you reflect back and search. So this knowledge system, which was very valuable, authenticated because it has been practiced from generation to generation. Human beings survived on it. No modern medicines, nothing of the variety. Every medicine or every food has its own limitation even today, but generations together. You can track the modern knowledge systems, but if you track the traditional knowledge system, India has more than 5,000 years of history.
Yes.
Human beings survived. Human being progressed. So it is part of your life every day. So everyone needs to understand what she was talking about.
Yes. That's powerful. That's really powerful. Yes. Yes, that's powerful. Well, this has been great. I think, I mean, let me just leave you. I mean, this has just been so great. Let me just ask you one last question in a nutshell. What is the thing that you think the public misunderstands the most about traditional knowledge?
Well, not the traditional people, the modern people think it is free.
The modern people. Yeah, so
It's
yes.
free.
The question was not going. Yes, they misunderstand that they think it's free, just
Absolutely.
free for the
They don't
taking,
understand
free for the taking.
because they think that anything you can take without permission is free. And there is no strong legal framework created to tell them, yes, it is free, but respect.
Right.
So that's a great misunderstanding. The industry thinks they can take it. The scientists thinks they can take it. The ordinary people thinks they can take it. Whoever is thinking that they need it and they use it. Unless it is kept closed. Then they go and observe everything they wanted to do to make sure that they get the benefit out of it. So it is this notion needs to be re-articulated. If I use the public domain in the modern IP context, we have a strong understanding of public domain in a context. That's IP context, copyright, patent, design.
That's true.
That notion needs to be re-articulated and reworked. And that's a central problem. And that needs to be addressed for the people misunderstanding.
Absolutely. Prof. Narendran, do you have anything you'd like to add? Any final thoughts on what the public misunderstands or what people should know about traditional knowledge?
Just like Sir said, it is the most important issue is that people see it as part of public domain. So every aspect, like whether it's traditional knowledge or traditional cultural expressions, people treat it as part of public domain. So when the misappropriation happens, they feel that it is something which they are legally entitled to do. So they many times doesn't understand the value and the importance of following the regulations or providing the benefit sharing to the community.
Yeah, and I think this is, these are really great
that is the main challenge.
Statements, concluding statements, because this is really where there is this gap between traditional knowledge and intellectual property rights, because the only reason people know that they can't just download movies for free or music or copy books is because we have the legal framework that tells them it's not free, because without intellectual property, all of that would also be free for the taking, right? So this is where the intellectual property rights become such an important part of this traditional knowledge conversation. So, Shri, I don't think I gave you a chance to wrap up your final thoughts before, right? Because you fell off. The internet connectivity issues.
I like the emphatic statement that Professor N.S.G made. The biggest problem with TK is people think it's free and it's there for the taking, right? So that's the best,
yes.
Right? So
yes,
and thank you for the opportunity. And this is
thank you very much. Thank you very much for the opportunity.
Thank you. I've had so much fun chatting with you. Thank you, Prof. N.S.G. Thank you, Prof. Naren. Thank you, Prof. Shri. Thank you so much for your time. And I hope we can have another conversation about maybe even how AI is scraping TK across the internet, because I think that's going to be the next big issue. So thank you so much.